discussion, I want to understand from all of you, how do you define gender diversity? So, Justice Shakdher, if you can just...
Okay, for me, when you talk about gender diversity, what comes to mind that this is not binary in that sense. It's not only about men and women. There are lots of persons, using that expression consciously, who do not conform to any gender. And even the most liberal amongst us don't actually think that far. We are only talking about men and women, which is why some of them haven't got an opportunity, or they reached a particular level and they were left out. When you talk about, say, intersex, it is obvious that there are genders or non-conforming genders which don't get slotted only as men and women. And once you start thinking like that, maybe there'll be more opening up. So that's my opening statement.
Dr. Guruswamy?
I think that as Justice Shakdher said, there's a range in terms of how human beings choose to identify, how they choose to define themselves. So there's male, female, there's transgender, so on and so forth. Look, in the context of the court system, right, because that's what we're talking about. We're talking about gender diversity in the court system. I would imagine that would mean in an institution like the court, that you would have a diversity in the context of sex, diversity in the context of gender, and diversity in the context of caste, because that is the spectrum as I see it, right? I mean, I don't think when I think about gender diversity, or when I think about diversity in a constitutional court, whether those are the high courts or the Supreme Courts, because you are seeing diversity in district courts. I mean, let's get into the conversation, right? You are seeing diversity in the district courts, especially in the state that we're in. I believe this is last year was the first year that there were going to be more women than men in Delhi district courts in terms of district judges. And within that spectrum, it is my hope that there's also been a diversity in the context of caste, religion, sexuality, and all the ways that human beings chose to identify. But when you're a judge, the way that you should be tested is your fidelity to the Constitution and the rule of law. So that's my conception of it. And since that's the topic that we've got together this fine Saturday evening to discuss, so I thought we should, that's the way I see it.
Great. Thank you so much. Mr. George?
Yeah, so just following up on what Justice Shakdher mentioned and Dr. Guruswamy mentioned, I think one important aspect whenever we deal with diversity is that one needs to also understand that within these categorizations that we make, there is a lot of internal heterogeneity. So, for instance, what she just mentioned, you may want to, let's say, take a category, say, of women lawyers who practice. But within that, there is a lot of heterogeneity in terms of the background. For instance, in the High Court or in the Supreme Court, what we see is that largely the feeder base is from the urban elite sections of society, right? That's how our educational system is designed. You want to get through a CLAT, good fidelity to the English language is like a sine qua non. You do not get through to that educational institution, right? So you don't tap into those social networks. So even within, let's say, groups which are traditionally, in that sense, disenfranchised, within them also there is a lot of internal heterogeneity. And that also is something that we need to address if we have to look at it from a more nuanced perspective. Because it's very simple to just categorize a particular community without looking deeper inside it and seeing who are the sections within that particular community, those subsets that in fact you need to target more in terms of providing opportunities. So I think that's also something, as both of them mentioned, we need to look beyond just the optics of categorizing them as a homogeneous whole, but looking internally into the inherent heterogeneity in any of these classifications.
Right, you have raised a very great point, and I'm going to discuss more on that. Coming back to you, Justice Shakdher, looking back at your journey, and how do you think judiciary has changed when it comes to diversity, and both in its judgments and who gets to be a part of the system?
So as Dr. Guruswamy just said, there have been some changes. One can't say that we've been completely glacial in that sense. At the district court level, especially in city courts, for example, Delhi or other even other high courts, which supervise under Article 235, the subordinate, or more appropriate expression is the district courts. There has been an upsurge in women officers becoming judges. There are some states where there are reservations for women in district courts. And there are others where there are no reservations. Even then, the number is increasing. The problem really is that in the superior, or so-called the constitutional courts, which is the high courts and then of course the Supreme Court, because the constitution doesn't provide for any reservation, whether under Article 124 or 217, they go by a thumb rule, we should have 2 women or 3 women in the Supreme Court, we should have X number of women in the High Court. That actually queers the pitch for, gender diversity. What Dr. Guruswamy said is diversity generally. Gender diversity is where we are saying you need to include other genders as well, or those who do not conform to gender. As far as the state is concerned, very strange. When they give you stats, they are very comfortable with social diversity and religious diversity. That too, in terms of stats. So they will say, yes, we should have stats for SCs, STs, OBCs, EWS. And recently, some time back, some question was asked. They gave some very healthy stats, correct? But when it comes to appointing, that's why I was stressing the point of having someone who doesn't conform to the 2 binaries that we are talking about. There's a complete mental block. They will not have someone who says, I am neither a man or a woman. I feel I'm something different. The society is not accepting it. And of course, the state is not giving any leeway for such appointments. It's very strange, and I think Amit and Dr. Guruswamy will remember in 2012, I was only 4 years into judgeship. A very happy appointment happened. Justice Vikramjit Singh, who was then the Chief Justice of the Karnataka High Court, appointed a transgender as a grade or a Group D employee. And I think Justice Altamas Kavi was the Chief Justice of India. He went there, gave her the appointment letter. But how many such appointments have taken place? Now, I'm not talking about judges, I'm also talking about diversity at the level of officers, whether it's Group A, Group B, C, D. Actually, we are not comfortable with the idea of being non-conformist. So, I repeatedly hear this from even, my colleagues, lady colleagues, or the ex-colleagues now, or at the bar now. Most of them will only talk about women. They will not talk about other genders, or, there's not enough talk about that. And why is that so? So one of our colleagues at the bar, he just couldn't get an appointment to the court. I mean, they processed his papers. We all know Mr. Saurav Kripal. It went to the collegium. They recommended it. They recommended it for the second time. There's no movement on it. Why? No one's asking that question.
Okay, I just want to understand from each one of you. You are talking about a problem, but what is the root cause of it? Is it because of the culture, some thought process, or we are not taking our education system? What is the root cause of it?
Well, I mean, the judiciary traditionally, there's a book by George Gadbois, which profiled the Indian judiciary, I think, from the 70s to the 80s. And it's an empirical work, if you read it. The judiciary has typically been Brahmin men, and there's no polite way of saying it. So that is the institutional ethos, right? Institutions have cultures, and it is the cultures of those institutions which, result in the appointment or the lack of appointment of certain identities of people, right? So this is the empirical telling of the court in those days. So it has been also an institution. And when you think of the history of the Indian judiciary, when the constitution was being written, there was some concern about the new Supreme Court to be. because we came from a colonial history. The courts played a certain role. And then you saw the judiciary wading in to the problems of the times of this country. You saw the judiciary come up with the institution of public interest litigation. You saw the judiciary come up with the collegium system of appointment. I'm making these points because this is unique to India. This is the strongest, the most powerful constitutional court on the planet. There is no constitutional court anywhere in the world that has the collegium system of appointment, that has given its country a basic structure, that has waded into an array of problems which traditionally were seen as governance problems, right? So for this court to then not reflect the diversity of this country is a contradiction, right? And that's the problem, that if you have chosen for yourself an institutional character saying that this will be the people's court, this will be the people's law, we will wade into non-traditional areas of adjudication. So by that I mean that these are areas where British courts or American courts or even Nepal's Supreme Court would not have waded in. But we have done that. We have given ourselves this mode of appointment. Then you must reflect. If you have chosen to be the most powerful judiciary on the planet, you must reflect the diversity of this country. I don't believe in this country that the people of this country have a problem with gender non-conforming people or with having religious minorities appointed to the court or more women appointed to the court, because Indian politics tells you that they don't have a problem. If you look at Indian politics in this country, you have single women who are chief ministers, powerful chief ministers of states. You have single men, single women who have chosen non-traditional ways of living their personal life. The Indian public does not care. So the idea that this society is not ready, right, for transgender judges or gay judges or more women judges or any of that, right, I do not believe reflects the reality of this country. I think that this is an institution that has been slow to change. And it's unfortunate because it's also an institution that has made the most amount of change in this country. It has spoken about constitutional morality. It has decriminalized homosexuality. It has rendered permanent commission in the armed forces. It has done so much, which has, some of those answers have not come from the executive and the legislature. It has done that. And therefore, it is with hope, as senior advocates and as lawyers at the bar, we look to our court. We look to our court with hope that they will choose to reflect the diversity of this great country. And it shouldn't have to be quotas. It should have to be the reality of this country, because you are wading into these countries' problems. And you are choosing not to exercise judicial restraint. You are choosing to not have limited judicial review. You are choosing not to have limited locus standi to go to court. So if that is the character that you have chosen for yourself, then your institution must reflect the diversity of the populace that you choose to adjudicate upon.
While we are talking about courts, I also want to understand that if we take Supreme Court bar as an example, do you think there is a diversity over there? And do you think we are still lacking?
Certainly, I have practiced law for 27, 28 years, right? I started in 1997. I have seen the bar become more diverse. And one of the reasons why, so whereas the NLU project is an elite institution, but what the NLU project has done is it has brought in first generation lawyers in waves to the court system. There are many, many more first generation lawyers that we have in court today. Many are successful. There are many, many more first generation senior advocates today. I never saw that when I first started practicing law. There are many more women. There are many lawyers across castes, across sexualities. So the bar is definitely more diverse. Is it diverse enough? No, we want more first generation folk. We want people from areas which are underrepresented to come join us at the bar. But I do believe that the bar is much more diverse than it ever was. This traditionally, the practice of law in India has traditionally been the practice of sons of judges and senior advocates. That has changed. And who is coming to law school is not that anymore. That is the big change that has happened. So the classroom has changed. The courtroom is changing in terms of the bar. The SCBA has changed. Every bar across the country has changed. I appear in high courts all over this country. And you can see that those bars have changed. Young people come and talk to me, and you can see who they are and where they come from. So certainly the bar has changed.
Do you agree?
Yes, absolutely. I definitely think so, because even in the short span of time that I have been here, relatively, say 15 or 16 years, I'll give you an example. Justice Shakdher would, of course, know the person. So I was clerking with Justice Enlaw in the High Court those days, 2009 to 10. And I remember he used to be on the arbitration roster then. And I remember being in court for almost 2 weeks and not seeing a single lady lawyer effectively come up and make submissions. The first one I saw was Miss Padma Priya, who's of course a very close friend of mine now, and she did such a spectacular job. And it wasn't because she was, say, a lady lawyer, but she was objectively so much better prepared than the veteran lawyer who was opposing her, and that's how she got the relief. But then it was such a rarity in those days. And then later on, when I would seek her out in the canteen, have a conversation with her, there were so few women. And now 15, 16 years down the line, there are so many more. And it doesn't seem awkward anymore, or it doesn't seem like it's a rarity anymore to see a woman lawyer opposing you or working alongside you. So that's definitely changed in those 15, 16 years. But again, as in the one point that you flagged in terms of why is this process slower, I think one problem is all of these judicial interventions that we mentioned, we see them as institutional interventions. I don't agree with that because of the polyvocal nature of our courts. So even though we would like to see them as responses from the institution, largely they are responses on the judicial side from individual judges who mean well and who have that judicial fortitude to strike a new path. But unfortunately, what happens with many of these interventions is a roster changes, an individual retires, and that pace of reform or that pace which you would otherwise anticipate from an institutional push then gets lost. So therefore, a lot of what we see, the change that we see now, is again because of how society is changing. Right? You have smaller families, nuclear families, girls are now being educated at par with their brothers. So therefore, the inflow into the system is naturally increasing. But it would have been so much better if the court had an institutional response to a lot of these issues, judicially or otherwise, which would have possibly led to a faster change. Like Justice Shakdher now mentioned, for appointment, say, of women judges, it's a very rough and ready sort of like a rule that we follow, right? And many a times, unfortunately, therefore, that leads to real, in that sense, not real emancipation or real diversity, but just tokenism. You want that one woman judge, and then your job is done. So that, I think, is one of the problems, that many a times these very good judgments that come in, we are happy with the judgment. But beyond that, in terms of real institutional change, the vast majority of the judiciary is not really behind it or not really driving it. So I think that is one of the problems why sometimes one feels frustrated, because you have a very good judgment which says exactly what it should say. But then you see on the ground level, the operationalization of that, even within the judiciary, is quite, paltry.
Right. So earlier at the bench, now at the bar, do you still feel that the issues of gender diversity exist both at the, which she says not at the bar is progressive. What is your thought on it?
No, as I said, there has been some change, but the change is minuscule. I may be in a sense, setting the cat among the pigeons by saying that there is tolerance, is there acceptability, open acceptability of going beyond men and women. We are not. Let's accept that and then move forward. And then try and change it institutionally, as Amit says. Unless you have an institutional change where even the judge, when he sits on the administrative side, says, listen, I have no leeway. This is the rule. This is the norm. Therefore, I have to appoint someone who is, or more women, or more of other genders, or non-conforming genders. Today, that is not happening. And I suspect, however much we may otherwise criticize Western norms, this is one area we actually are adopting Western norms. It's a white Western construct that it is only men and women. And this is something which has come up, I think, in the 18th century, if you go back. And this is where the state's role comes in. Courts can do only so much. The state has to educate people. The state has to step in. if you go further, it was accepted that there were other genders as well. And people are these days very fond of mythology, and I may tell you, and Amit will know something. Lord Sabrimala, as per your mythology, is conceived from a copulation, so to say, of Lord Mahadeva and Vishnu in Mohini form. So this aspect, even in our religion, if you accept that, and people are fond of going into that, why don't we learn from that? And just accept a construct which is actually alien to Indian philosophy and thought. And once you accept that, you will find diversity of all kind. You will say, okay, as long as he's not what I am, but I'm willing to accept that other person, you'll slowly find that there is diversity. And the point that Dr. Guruswamy made is about a particular class, or I don't like to call it caste, which has control over various institutions. That's an honest fact. But why doesn't it play out outside the court? Because that class is only 4% of your population. You have to accept that the vast majorities, when they combine together, whether it is SC, STs, OBCs, they will swamp you. And therefore, you have to tolerate them and not accept them. I come back to the point of acceptance and not tolerance. And that is the grouse and grievance in our society today. People say, I'm not given my right by, you accept me. You find stories. People who belong to, say, who are scheduled caste. They'll say, even if I'm a minister and there is someone who's a Brahmin who's a minister, he'll ensure that either he'll not eat from the same, plate as I am served on, or make me sit on something which is lower, in height or whatever you may call it, so as to make you feel that, he others the other person. But he tolerates him, he needs him for whatever. That's the problem here. This, according to me, it won't change at the pace at which we want the change unless the state steps in and says it's quite all right to have, more women, more non-conforming gender persons. It won't change, and which is why the court can do only so much. I mean, I gave you the example of Mr. Saurabh Kripal. The onus is actually there, and I don't know, it's between the two. I mean, one institution they can do only so much. Because then there is rupturing of the equilibrium, and that's what the court doesn't want to do, because they have to balance that.
Yeah.
And therefore, they don't go beyond a particular limit, not because they are not aware of the fact that this is not fair.
I think we are not having acceptance of women also. Today, we have only one Supreme Court judge, and we are asking them to go beyond. But we are right now, it has become only a men's institution.
No, I accept. My problem is when you only reduce it to saying only women. And why are you talking? I started by saying, why are you talking about quotas? If there are 5 good women, appoint all 5. Why do you only restrict yourself by saying it's an intellectual exercise? It's not a weightlifting exercise. Some women are stronger than men also. I mean, it's again, some kind, you conform yourself that all men have muscle and all women have, don't have that. But that's wrong. So what I'm trying to say is, you actually shortchange yourself by asking for quotas. You shouldn't be asking for quotas. You are saying, we've arrived, we are in large numbers, and appoint more of us. That's the way I would fight this, rather than...
But we cannot, please.
I see, there's absolutely no question that, in Indian society, you've never had this kind of firm binary, right? I mean, even 377 was a great British gift to our people, right? So that's a given. But I think the reality is also that, when it comes to the appointment of women to the court, the numbers are stark. I mean, the numbers are astonishingly stark. Court of 34 judges, 1 woman judge. And this is one of the great constitutional courts of the world. No other constitutional court has that kind of starkness. Not Brazil, which is much more comparable to India, because it sees that same kind of bulk of 40, 50,000 cases a year. It's not a small court like the American Supreme Court with 9 judges, which only handles 60 to 80 cases a year. So even the courts that are comparable, Colombia, Brazil, the great Latin American courts, all have more women. And I don't think it's about quotas and numbers. It is about the treatment of the intellect in a very sort of equitable and fair way. And that is really, you would want the best people, whether gay or straight, male, female, everything in between, upper caste, lower caste, scheduled caste, OBC. You want the best people in your district courts, in your high courts, and your Supreme Court. And when the numbers are stark under 10% in some high courts in this country in terms of women, the great, high courts of this country, at partition, it was Allahabad, was the court in question. You look at the numbers of women judges in Allahabad today. When I argue cases all over this country, I do a lot of criminal law. It's very interesting. There are wonderful women judges in Chhattisgarh, in Bombay, in Orissa, in Telangana. You can see them. I've appeared before them. You should have more women judges at the Supreme Court. And it is not about, it should never, I agree with Justice Shakdher, it should never be about quotas. Women are 50% of humanity. Surely there can't be a quota on that. But really the question becomes, why does representation matter, right? This is the real question. Why does diversity matter? And that could be diversity across gender, sex, caste, religion, any of those markers that I would expect any constitutional conversation to take into account, right? So why does diversity matter? Diversity matters because it speaks to the legitimacy of an institution. The moral legitimacy, the way the decisions of that institution are received. So much of this is about who comprises the institution. And whatever we may say, Indian politics has changed. Politics in India today does reflect the diversity of this country. Whether it's across caste, whether it's across sex, whether it's across class, politics reflects the diversity of this country. Our political institutions, certainly Parliament has some way to catch up, but nonetheless, you do have prominent women politicians in Parliament. They're articulate, they're vocal, they're there, they're elected, right? There is no constitutional institution that has such stark numbers except the judiciary. There is no constitutional institution in this country. And when you are talking about 50% of humanity, and then you can break it down in the context of religion and caste and sexuality, it cannot be this. It cannot be this because this is an institution that we care about, right? And that's the heart of it. You want this institution to have moral legitimacy. And institutions have moral legitimacy when the composition of those institutions reflects the reality of this country. Right? So we can have ideological debates about the opposition, the ruling party, so on and so forth, and that's completely fine. But the composition of political parties is reflecting the realities of this country. And so you have those, today, one of the most interesting thing about Indian politics is the diversity of political parties, the number of political parties, the issues that these political parties raise, and the way people vote in this country. Right? It reflects enormous diversity. So the courts need to reflect that diversity. I think that, if quotas is how women are appointed, then it's kind of pretty stark at the Supreme Court.
But how do we bring diversity in?
No, I think it is about the lens with which you view suitable, qualified candidates to become judges. And that's the point. The lens should be an equitable lens, which evaluates them in terms of temperament.
The current situation?
No, I think it's about evaluating temperament. It's about evaluating experience. It's about evaluating track record. And it's about evaluating your life journey. Why is it important for us to have more diversity in the court? Because different life experiences matter when you're adjudicating constitutional questions, and when you're in this business of constitutional adjudication, then the disparity and the differences in your life experience are enormously important. That is why the differences in our experiences, whether it's caste, whether it's gender, whether it's sexuality, whether it's religion, all of it matters. Because when you have that morning coffee together as judges of an institution, you need to be able to break bread across these categories. Because that is how we grow as human beings. And each of us, have different life experiences that we bring to the table. And that is how we approach problems. The judiciary is no different from that. They need that wisdom that comes from a diversity of life experiences, whether it's being male and female or everything in between and beyond, whether it's different religions or not practicing a religion. There are those diversities of life experiences, of faith that needs to be heard. So I think that, the numbers are stark when it comes to the judiciary. And we want to see those numbers change.
Yeah, right. Well, Mr. George, if you want to comment
Yeah,
on
so
this. I also want to rephrase my question. Do you think we need to have a specific number reserved, that these particular number has to be reserved for women judges, so that these things doesn't change? Like right now, only one women judge. And everyone is talking about it, but no one can do anything about it. So I just want to understand that.
Correct. So I think I would just try to refer to Santos, the social theorist of Portuguese origin. So he has a very interesting take on cosmopolitanism. Like, we have a global village now, and all of us coming together. The internet has, to an extent, dissolved a lot of those geographical boundaries. So we all celebrate, globalization, or that global cosmopolitanism that is afoot. Now, Santos somewhat calls out, this phenomenon, and he says that unfortunately what has happened is that this cosmopolitanism has in fact gotten hijacked by power centers that rely on privilege. And he therefore says that we should aim for something he calls a subaltern cosmopolitanism, which in fact, takes into account the lived reality of people's lives, as she mentioned, and ensures space for all kinds of people. Now, as you said, putting in a quota is a hard measure in terms of ensuring that the system in fact ensures that particular representation in numerical terms. Now, considering our experience so far and what she mentioned, how stark it is, in my view, it is time that we have to start thinking along those lines, because frankly speaking, growth is glacial, progress is glacial. But my bigger concern is this, that if, as Justice Shakdher mentioned, if it is only going to be an attitude of toleration, then even with these quotas, you will find that the quotas are also weaponized or used in a manner in which that existing status quo or privilege is perpetrated, even though we have these appointments being done. So therefore, what we require more, as Justice Shakdher mentioned, is this attitude of toleration, because otherwise that quota will remain only that you fill in that numerical number, but you ensure that the kind of people who are brought in are people who you are tolerating, or are people who you are ensuring don't really have a say. To give you one example, you have that particular quota saying so many women judges. Now, concertedly, you may ensure that the women you elevate to the bench, you elevate only in their mid-50s. Or you elevate at a time when they have 4 years left, 5 years left. Then what happens to your quota? Because that change that would otherwise come about, you are ensuring it does not, because you have these isolated voices who you are ensuring do not reach that position, either because of seniority or otherwise, where they are able to actually be change makers. So as I said, one solution to this is possibly a quota, but these are all things that you can game ultimately to really ensure that status quo prevails. So that is one way of looking at it, but what we really need is, in that sense, that institutional sort of like a shift. It's very easy for me to say this, it's difficult to put into practice, but a lot of these solutions that we have, what we don't realize is that they're extremely easy to game without not much substantially changing.
So how could we redesign the way to
See, why did I say that quotas won't help? Let's look at some empirical data. As I said, in the district courts, some district courts across the country, there is a reservation. And there are others where there is no reservation. And if you look at the data, I had looked at the data, recently, and I found that where there was reservation, the percentage of women judges was less than places where there was no reservation. Why is that so? It is because maybe, and this is only an intuitive guess, that the society there is more accepting rather, of women being part of institutions. Which is why I keep coming back that the state has to play a very, very proactive role, that women are 50% or half of your population. They have to be allowed to get into these institutions so that they can make those changes. And therefore, this quota, as Amit says, it can be gamed. It's so simple. You elevate them at a ripe age of, say, 59, 58, or maybe a little 1 or 2 years less. You don't really have much say. You don't get into the collegium if the collegium system remains the way it is. How do you ensure that you make more appointments? The present incumbent, Justice Nagaratna, will get only, about a month? 34 days. Before she comes into the collegium, or becomes the Chief Justice rather, she would be kind of on her way out. I'm sure she'll make and try and make good use of those 34 days as Justice Lalit did. He made phenomenal changes in those 70 odd days that he got, 74 days or odd he got. So if you have the intent, you can do it. But then you don't have enough. I remember Justice Rumapal, because one of the finest judges that we had, who should have been the Chief Justice, who didn't make it as a Chief Justice. But she played, if you believe in what you hear in the bar, and I have no reason not to believe, she was one of the strongest members of the collegium. And she took the collegium in the right directions on most crucial decisions. So, firstly, you have to decide, is it a deep selection process, or is it merit comes suitability, and therefore the more senior you are, do you get into the catchment area, or are you going to do deep selection? There is no set method. I think deep selection is something which is good, because when you elevate a person to a constitutional court, that's the High Court or the Supreme Court, you must look for talent first. You must look for, the ability to sit for those number of hours, deal with people, because temperament is very important. You may be a great lawyer, you may not be a great judge. There are rarely people who do both. But we've had examples of people who from the bar came to the bench and then said, no, enough, we are going back, because they didn't. They suddenly found they didn't have the temperament. So those are two areas that you need to look at. Are we seriously looking at that? And then, of course, your number of years at the bar, your experience. And then when you look at experience, and Menaka made a very good point, it's not just about law. Law is not just what you read in text. When you sit at the bench, it's a whole lot of things, especially in India. So if you've worked in different fields, you bring all that experience, and that translates into a judgment. So, and one correction I think that they can make, especially if you want to encourage people from the district court to put their heart and soul into what they do, is perhaps make more accommodation for them in the highest court. There are very few people who from the district court have got appointed as Supreme Court judges. So suppose if you have to have a quota, why didn't you at least broadly agree that 2 people from the district who've started from the district court can end up there? You'll see a transformation, because what is happening here is, when you come to the High Court, their struggle is to get to the High Court first. And once they come there, they think, this is my Mount Everest.
I think Justice Bhanumati comes from the
Yes,
district
she does,
court originally.
Justice
then
Bhanumati, and there are a
comes
couple
from the
of
Supreme
more.
Court.
No, you need to encourage that if I work hard and I've proved my mettle, I can get to the last court.
Yeah, absolutely.
And Justice Bhanumati also had a long tenure in that sense. So therefore she reached the collegium. So therefore there was a matter of moment as far as her appointment is concerned.
So from my personal experience, that I have seen that women are appointed at the level where they do not have the decision making authority, or to the highest level. I have worked in an organization where 80% women were there, but not a single woman as director, not single woman as VP or GM. But here, as you mentioned, that we have many women in district judges, as a district judges, but there are few women, only 13 women as High Court judges and 1 woman as Supreme Court judge, because the mindset is that at the lower level, and this is what I from my personal experience, that they are not being given position at the higher level.
No, I think, look, it's a couple of different things, right? Because the judiciary also exists as a part of this country, right? So the average Indian today is 28 years old, 28, right? Judges tend to be a little older than the average Indian. And it's very striking to me, right? If you go to district courts, the energy is extremely different, right? From the time when I first went to district courts and when I practiced in criminal courts. Today, you see an extraordinary number of young men and women and folks in between, right? Who are idealistic, they become district court judges, they're practicing in the district courts. Who is that typical district court lawyer in Delhi is an extraordinary story, in terms of this country. You could be a young person who's come from Bihar, who's come to take the UPSC exam. You've taken it 2-3 times. You just stay on and you start practicing law. And this could be a story of Bihar, UP, Madhya Pradesh. You'll come from a farming family. This is also the typical person who comes to district court. From this, you will have young people then aspiring to become district court judges. And they will pick cities like Delhi to start their careers in. Right? So there is an enormous amount of change that is happening. You want to see that change percolate upwards. Often you'd say that institutionally change percolates downwards. But here you want to see that change percolate upwards, and you have to do it. And I'll tell you why you have to do it. Because it is what politicians in this country have learned, that young people are impatient for aspirational change and for their aspirations being held true. And this is going to be true for young lawyers. It is true for district court judges, because they would want to see these institutions change. Because if young people don't see institutions change, then the legitimacy of those institutions and their faith in those institutions crumbles. It's quite simple. The change you are seeing in South Asia is momentous. The change you are seeing today happening in Nepal. I spent many years, helping out, advising, supporting constitution-making processes in Nepal. What you are seeing today, where young people are burning down institutions, right? Whether it's parliament, whether it's minister's home, is because of impatience.
Yes. That
traditional elites have let them down. This is the story in Sri Lanka, this is the story in Pakistan, this is the story, Afghanistan. We have to learn that we need all our institutions to reflect the realities of our country. And importantly, you have to hear the aspirations of the young people who compose and come to those institutions with faith. Because if you don't hear that and you don't see that, then institutions crumble.
And one last question on this topic. What happens after 5 years? Do you see things might change, or we can educate the state, or we can through these conversations, some reform can be brought in? What happens after 5 years? Are we still lingering on with the same thought process?
See, ordinarily, when you talk about the state, you talk about the executive, and when you talk about the executive, you talk about whichever dispensation is there, and normally they have their ear to the ground. When the change takes place, they are the first ones to know, not institutions like ours, the courts. And but here, what we all know, because of the recent developments, that change is taking place in our neighborhood. Do our politicians have their ear to the ground? If they have, it's my belief that they should take corrective measures very quickly. Because if it doesn't happen, people are in a sense becoming despondent, if not losing faith. Why isn't the brightest guy becoming the judge? Why isn't the brightest woman becoming the judge? And when people make that effort, and I don't want to get into specifics, suggest names. Why are they not approved? Why don't they go through? I don't know. Those women need answers.
Yeah.
It's not fair to tell them, listen, your names went up to a particular stage and then they sort of fell off. Someone had to back them. They were not backed and therefore they fell off the rails. Now, if the state doesn't heed these symptoms, then there will be a problem at some stage. People will lose hope. I mean, it's not good for the institution. That's what I can say.
Your thoughts?
You want the best young people, in your courts. And I meet so many bright people, I'm sure both of you do. You want the best young people to aspire to become judges. You want talented young lawyers, young law graduates to say, "Mujhe judge banna hai." The way you get that is if your appointment system lets that diversity come to court. And if young people start feeling that it is a closed appointment system, that I have to be so-and-so's son or so-and-so's grandson, and it's really sons we're talking about if you look at the numbers, then you're never going to get the best people wanting to become judges. And at the heart of every good institution is pride, right? If young people don't feel pride in the institutions that they participate in, then you have nothing. Then you have nothing. Then you're just an institution which files are moving through, right? So when we go to law schools, and I go to law schools, I want to hear young people say, "Mujhe judge banna hai." And I don't know that we're hearing that. I don't know that we're hearing that at all, because there is such despondency. What is the message that goes out to a young female law student or a young gay law student today? What's the message? What is the message? Can you become a judge? And I think that's all that appointment systems need to reflect on. That is all they need to reflect on. Because if you don't have that, you don't have a buy-in to this institution. And implementation of judgments is about people buying into you and buying into your power and buying into your adjudicatory wisdom. If they don't buy in, your judgments don't get implemented.
Right. Thank you so much for saying this.
And I'll just add one thing to that, what she rightly pointed out, and Justice Shakdher, of course, alluded, but I'll just mention the person. So we had Ms. Shwetashri Majumdar now in the High Court, first generation lawyer, and made a name for herself in otherwise a field which was very difficult to get ahead in. She's offered judgeship at a very young age. She says yes, and as Justice Shakdher pointed out, goes to the last level of approval, but inexplicably, apparently the name falls off. Now, of course, she withdraws her consent. Now, one problem is, of course, as she pointed out, as her pointed out, that a lot of people now, like young women, they look at that and they believe that, this system is not for us. But a more troubling trend is the unarticulated message that goes across that you need a godfather. And I think that is more dangerous. Because somebody backing off saying, I don't need this, is one problem. What is worse is for us to get this culture in that you need to curry favor, there has to be a godfather. See, because as individuals and as professionals, when we practice law, there are people or individuals who are bound to take a liking to us, right? That's subjective. Judges who may like you, who may promote you, fellow lawyers who may promote you. But that is something that should come from your temperament, who you are innately, and from your performance as a lawyer. It should not necessarily mean that you need to target a power center or curry favor with a particular individual for you to desire. And Justice Shakdher, of course, has spoken about this, how unlike earlier when it was offered, now it is something that is actively targeted, and sought for by people who are desirous. Now, this is part of that culture, unfortunately, that unless I have somebody backing me, somebody who I have curried favor with and somebody who will back me to the hilt, I am not going to be able to get through the system of selection. So that is also dangerous in a way, because for a young lady lawyer to be told that you must have a godfather or a godmother, right, and you must keep that person happy or you will not make it, that is also a troubling sort of like.
Godmothers hote nahi hai.
No, I'm just saying 5 years down the line, even if you have a godmother, that's also troubling.
So can I just complete this, wind this point up, because these two have been only on the other side of the bar. I have been on this
Sahi,
side also.
sahi.
And therefore,
My
I have a
lord.
little bit of
My
an
lord.
insight. You know, the most troubling thing for me was, and I don't want to embarrass my friend Amit here, which is I had made offers, in the sense, invited them. They didn't come to me because that's the traditional way. Lots of young women and young men. And some of them said, sir, we don't want to be part of this jing bang, because the way the process ends up, I mean, you put your name there and say, okay, go ahead, put your hat in the ring, so to say, and then it doesn't happen and we don't know what is the reason. Now, if 3 High Court judges, which includes the Chief Justice of this court, has applied his mind and said, these are the candidates we think should go through, there should be a very good reason to say, no, they are not good enough. Or at least a consultative process between the High Court Collegium and the Supreme Court Collegium, if not the Collegium, at least the Chief Justice of that court. See, the Constitution provides, even for appointment of, before the judges' case, judgments came, that they can consult even a High Court judge for appointment of a judge to the Supreme Court. Does that happen? It's all on paper.
That's a fair point.
If Ambedkar came to tea today and went to the Supreme Court, what would he say? I think that's the question. What would he say? 77 years after the birth of the Republic, what would he say?
There's a statue. He has a statue now.
Yeah, he would see a statue. And then what would he say?
And look at Gandhi and then say,
Yeah, we need more conversations. When we disagreed then, we need to further those conversations. Yeah. Yeah.
Okay, thank you so much. I think it was a great conversation, and I think I had a lot of questions to ask, but due to paucity of time, I'm ending this conversation here. But thank you so much for joining.